Well, I'm not quite sure how many people we have logged in right now, but I'm going to assume that we have enough to make it worthwhile to start this webinar. This is the second in a series of Bringing Clarity to webinars, which we're giving here at Terra Firma Chambers. We're obviously live now. It's being recorded at the same time, and it will be available, I think, on YouTube afterwards, but you can always contact Emma to find out about that. And the format is going to be that without much by way of introduction, I'm going to hand you over to the first speaker. We'll then go through speaker 1, 2, 3, and 4. There'll then be a question and answer session, assuming we have time, and you can actually type in questions. I think there's a QQ facility at the bottom of your screen. So with that mechanical introduction, we're talking today about insolvency law, and of course it goes without saying that insolvency law is an important area of the law in the background at any time. It never goes away, but it's becoming, and I think in the near future is going to come to be acutely important for obvious reasons, given that the government's job protection scheme can't go on forever, and sorry, in the case of many businesses, it won't be enough to save them. So we're going to be hearing a lot, I'm sorry, about insolvency in the next, in the remainder of this year, just as we're going to be hearing all sorts of complications about employment law, I think, as a knock-on effect. So having said that, I'm going to hand over straight away to David Logan from our chambers, who is going to speak about insolvency, the contractual implications. David, over to you.
Thank you, Michael. What I want to do today is highlight how I see the world changing as the Health Protection Coronavirus Restrictions Scotland Regulations 2020 are wound down. At the moment, our economy is taking its worst hit since the Great Frost of 1709. Estimates vary, but the OBR is forecasting something like a 35% drop in GDP over the current quarter, and that's certainly consistent with the PMI figures out this morning, which are 13.4 for services. Absolutely unprecedented. What we're seeing the government also forecasting is a quick bounce back from that, but I think there's some pessimism already creeping in about that. And Ernst & Young, for example, are now forecasting it may be some years before we get back to the level we were at before the virus started. So in a contractual context, I think the important starting point is the regulations themselves. And in that respect, if I can move on to the next slide, we see Regulation 5, which is the one which actually controls movement. The principal point of these regulations, of course, is to close down certain specific premises like pubs, restaurants, cafes, gym, bars, nail bars, that sort of thing. But it's this regulation, I think, that's actually had the bigger impact, because this is the one which is keeping us at home. And what we can see from that is that we really are only to go out of our houses when such conditions apply, as are found in Regulation 8. And if we move on to the third slide, I think we can see the one part of Regulation 8. It's quite a long regulation with a surprising number of exceptions. But this one is that we're allowed to leave our houses to travel for the purposes of work or to provide voluntary or charitable services where it's not reasonably possible for that person to work or to provide those services from the place where they're living. So if you have to go and do something on a particular site, you can do it. That's important from a contractual perspective, because if, in fact, it is argued that a contract has not been fulfilled, has not been done, there may be an argument for saying, well, actually, under Regulation 8F, you could have gone and done that. And that is an issue which I suspect will come up in future cases. The next point I would want to mention is what these regulations don't do. There's nothing in these regulations that affects the issue of prescription. And so there's no need to, if you need to raise an action to beat triennium or quinquennium in terms of contractual disputes, then the action still has to be raised. In my experience, and I've had a few of these, what you need to do is you have to make an application to the Sheriff Clerk explaining why the warrant is required as a matter of special urgency. You will then get that warrant, allow you to serve the action, which will then be automatically assisted under the current position. The regulations don't do anything which affects the traditional law in respect of either frustration or force majeure. And so if we move on to the next slide, some of the old familiar law will become relevant. For example, the Cantier-San Rocco case, which those of you who still remember the university days will remember, related to a case where someone had been contracted to supply a marine engine to someone who then became an enemy alien with whom they were no longer allowed to trade. And the question was, what happened to the money they paid on deposit once the war was over? There's nothing like that in these regulations. There's nothing in these regulations that makes any implementation of any contract impossible or illegal. And that is, again, it's going to have significant implications. I've also mentioned on the slide there the Canary Wharf case, which is a more recent case involving the withdrawal of the UK from the European Union, and the European Medicines Agency, which had a large office in the Canary Wharf in London, and tried to claim that the UK deciding to leave amounted to frustration of the contract. They did not succeed, but the case contains a lot of very interesting discussion about the law in those areas, and is a good point to start if you're required to investigate that. The next thing I would want to mention in the context of insolvency is that there are obviously two types of insolvency, and they're both going to be in play here. There is the inability to pay debts as they fall due, and then there's balance sheet insolvency, where the debts of concern exceed the assets. Now, government loans can help with the first of these in terms of cash flow, but they don't help with the second because they're simply piling up debt on the balance sheet. And that's one of the reasons that the banks have been so slow to progress loans, even although there are certain bank guarantees, government guarantees, I should say. Most businesses now have been accumulating overhead and minimal income for several weeks, and how they can sustain that going forward will vary from case to case. But I think those that have personal guarantees to their banks for loans should be thinking very carefully about whether further trading is a good idea. I'm not sure how a cafe or a pub, for example, can expect to trade profitably when social distancing measures are still in force, even if they're allowed to open. And the days of having to fight your way to a bar for a well-earned pint or a glass of Prosecco are unfortunately going to be a distant memory. We've heard quite a lot in the discussions about this dreadful virus that there may be a second wave of the virus once the restrictions are uplifted. But my fear would be that we'll also have a second wave of insolvencies as the taxes that are being deferred from July this year and the VAT payments that have been deferred on each quarter become payable in January. Many businesses will struggle to pay generate the income over the next 8 months to pay the outstanding tax and the tax that then becomes due. And there are consequential risks for businesses that are even solid in themselves, in that they are likely to have unprecedented levels of bad debt and the non-performance of contracts damaging their balance sheet, often beyond repair. I personally think that a lot more help is going to be required in that respect, and Bill is going to give us some idea on the latest thinking that the government has as to what they can do to address this. Going back to the contractual level, I think it's important to think about the implications of this massive change in our economy for individual contracts. To take the simple example of employment contracts, there are currently 6.3 million people on furlough and a cost to the government of over £8 billion at the present time. That at the moment is not in a business interest to make those people redundant. But I suspect that come July, when the scheme is due to be wound down, there is likely to be a very large number of redundancies for those that decide their businesses are no longer viable in any conventional form. The government has hinted this morning that this will not be a cliff edge, and there may be some sort of phasing arrangement, but the details of that are still to be unclear. Those people who had their contracts of employment unilaterally varied by employers may well have claims arising from that. Quite a lot of employers, for example, have not paid 100% of wages, and people put people on the 80% that they've been getting from the government. They don't have a contractual right to do that. And so for many, they will have a claim against their employer if that was not done by agreement. It's possible, unfortunately, that many of those employers will have gone insolvent. But the right to get payments of wages is a preferred debt. I think we'll move to the next slide. We can see that there's a general provision about preferential debts, of one of which is outstanding wages and pension contributions in terms of Section 175, and that's backed up by Section 386 and Schedule 6 of the Insolvency Act. Insolvency, or even the type of CVA that Michael is going to discuss, is usually a breach of the lease. And although there are certain statutory protections that Michael will talk about, there is a mixed blessing in this for the landlord. Clauses dealing with insolvency will vary enormously in the complexity and sophistication, from a bald declaration insolvency as an irritancy of the lease, which may give the company undergoing, or a more sophisticated clause, which may give the company time to reconstruct over a limited period of time, so that the new company can carry on with the lease. Each case will depend on its own terms, of course, but again, from a landlord's point of view, I think you'll have to realise that we're going into a situation which will be a tenants market, the likes of which we've never seen. Thousands of properties are going to be vacant, and the priority for most landlords is going to be keeping someone in their property, paying the rent, any rent, and also paying the council tax liability that would otherwise attract to them. So from that point of view, I think rent holidays, which have already been a feature of the close down, are likely to be extended, and renegotiation of rents downwards is inevitable. A further category of contracts which may be affected are insurance contracts, specifically contracts dealing with business disruption. And you may have seen already in the papers that there are a series of action groups looking to scoop up claimants against insurers who are seeking to argue that the pandemic doesn't fall. Yesterday, the Financial Conduct Authority said it was going to bring a test case challenging some of these provisions and ascertain a ruling from the court as to whether or not pandemics were excluded or not. I'm not sure how the solicitors who have been working so hard to put these action groups together will feel about that, but that is certainly something that's likely to come to pass in the near future. If we move on to the next slide, we're looking slightly different position, which is the question of where does the contract stand where an administrator has been appointed. And Section 44 of the Act provides that the administrator is generally an agent for the company. He has personal liability for contracts he enters into himself, but he doesn't have personal liability for contracts of the company unless he chooses to adopt them. It's possible, but unlikely in my view, that they will adopt leases, for example, except where there's going to be a pre-pack, again, something Michael mentioned, or a very brief interval of office, because why would they want to take that risk? Where they are contemplating carrying on the business and continuing that, I suspect will be fairly urgent renegotiations of the leases of the type that we saw with Houghton Fraser and to some extent Debenhams, even before the businesses moved on. A liquidator or receiver does have the right to adopt contracts as well, and where they think that such a step is of interest to the relevant creditors. And that may prove deeply unattractive to the other side of the contract, because, for example, they may find themselves in a situation where fulfilling the contract is now a lot more onerous than it was before the lockdown. There is a right under Section 186 of the Insolvency Act, which I think is set on the next screen, which gives you a right to apply to the court for you to essentially to be relieved of such a contract. That was supposed to be extended to receivers as well by Section 45 of the Bankruptcy and Diligence, etc., Scotland Act 2007, but 13 years on, for reasons that are not clear, that is not yet in force. Those of us who are old enough to remember the 1991-92 recession may recall that one of the major sources of work after that was insolvency work. And I myself did little else for about 3 years. My memory was that construction was a particularly lucrative area where modest margins, low-ball contracts, and unexpected additional costs relating to supplies, getting men on site, and the consequences of the work being left exposed for many weeks will be significant. Certainly, submissions should be made in construction contracts for extensions of time, but what other remedies are available will depend on the particular contract. From a business perspective, as solicitors, I would think that indeed as counsel, developing the insolvency part for your business is likely to be a very good move over the next few months. There are going to be a lot of interesting issues arising from coronavirus and so forth in terms of how contracts are being implemented and where the risks for those contracts lie. I think we move on to the last slide, slide 8. We see conclusions in relation to this. So there's going to be a very severe recession. There's going to be, there are no specific contractual provisions in the regulations themselves, but there are going to be knock-on implications for them. You have to be very careful about prescription, and I would urge you to work hard to get develop the insolvency part of your practice, because it's going to be busy. With that cheerful thought, I'll pass you back to Michael. Mike.
Thanks very much, David. I've just unmuted myself. Thanks very much for that talk. My subject, as you can see, is company administration under the Insolvency Act. The 2 points here are all administration is under the Insolvency Act, and it applies to companies and now to LLPs. I'm just going to talk about companies, but everything I say about companies would apply mutatis mutandis to LLPs as well. First of all, a bit of history. Until the Insolvency Act 1986 came into force, there were really only two statutory mechanisms for dealing with companies in insolvency. One was liquidation, the purpose of which was just to sell the assets of the company and pay off the creditors. The other was receivership, which happened where the holder of a floating charge, typically a bank, appointed a receiver. He ingathered the assets subject to the charge, normally every single asset the company had, paid the floating charge holder, and if there was anything left, which there normally wasn't, he would hand it back to the company, which by then would in any case be going probably into liquidation. So that was the position then. Then we had the Insolvency Act 1986, which kept, of course, liquidation and receivership, but added this new creature called administration. And it was added because in the early 1980s, there had been a very substantial review of insolvency law, corporate insolvency law, which was crystallized by what was called the Cork Report. And the Cork Report recommended new legislation to introduce what has come to be known as the rescue culture. And that is what we see as what underpins this new creature administration, well, newish creature administration. It's the rescue culture. So if we could pass on to the next slide, just a quick note on some of the characteristics of administration under Part 2 of the Act. I'm going to come, obviously, to a more recent exposition soon. First of all, there's a statutory hierarchy of purposes, starting with the principal purpose of trying to rescue the company as a going concern. Crucially, there's a statutory moratorium to stop the creditors from attacking the company when it's reorganizing or doing whatever it's doing under the administration. I'll come back to that. Quite importantly, as a matter of mechanics, the only way you could put a company into administration originally was by petitioning the court. The company could petition, the directors could petition, creditors could petition. So, but it had to be a court order appointing the administrators. Perhaps curiously looking back, the holder of a floating charge could still appoint a receiver under the floating charge who had the prospect of a receiver and an administrator both in office at the same time. There were restrictions on the ability of administrators to pay dividends if they thought the company was in a position to pay its creditors at all. And finally, although the idea was to rescue the company, inevitably, you would get to a stage where any rescue that could be done had been done. The company was left as just an empty shell and had to be liquidated. And under the Act as originally passed, and these provisions, by the way, are in Part 2 of the Act, or were in Part 2 of the Act, you had the administrator with statutory power to present a petition to have the company wound up and himself appointed as the liquidator, which gave, of course, continuity of control of the company. That was then Part 2 of the Act, which had just a handful of sections. Then we had the Enterprise Act 2002, which replaced Part 2 of the Act with a new schedule, Schedule B1. Why isn't it Schedule A1? That's because Schedule A1 is actually dealing with company voluntary arrangements and with a moratorium under CVAs. So it's Schedule B1, which is quite lengthy and is a statutory code, effectively, of administration. Once again, we've got now the statutory hierarchy of purposes. I think perhaps now if we move on to the next slide, this will become clear. We've got the second item, we've got the statutory hierarchy of purposes of administration. It's now a bit messier. We've got the fact, and this is really important in practical terms, that you no longer have to petition the court for an administration. You can if you want to for some reason, but in fact, now you can have an out-of-court appointment, which is a form-filling exercise by the company, by directors, by creditors. A big change now is that the holder of a floating charge, now called a qualifying floating charge, cannot appoint a receiver. I use the word receiver as a shortcut. Cannot appoint what's called an administrative receiver. That's simply, I think, to distinguish what we've always called receivers up here from English receivers under the Law of Property Act, which have nothing at all to do with this area of the law. So now, the holder of a qualifying floating charge, once again, typically a bank, cannot appoint a receiver if the company's administration. Also, bearing in mind that a floating charge holder tends or tended to have all the assets hoovered up in its favour, there is now a prescribed part of a relatively paltry sum, a few £100,000, for the unsecured creditors, even if there is a floating charge. It's a bit easier for an administrator to pay a dividend, and when things come to the end, either because the administrator thinks that the purposes of the administration cannot be achieved, or because he thinks they have been achieved, the administrator can now convert the administration into creditors' voluntary liquidation with himself as the liquidator. He doesn't need to petition the court. He fills in a form, and this change to liquidation occurs the moment that form lands on the front desk of Companies House and is date stamped by the clerk. So if you can go to the next slide, importantly, what exactly does an administrator do? His first mechanical task is to take control of the company's assets. And if you deal with administrators of companies, they'll tell you that they spend really the first couple of days talking to the directors, talking to the managers, looking at the asset registers, working out the details of the company, what it's got, what possibly can be rescued. They have to consider what to do about the directors. The administration does not automatically terminate the director's appointment, but in fact, the administrators can terminate the director's appointments themselves if they want to. Crucially, what to do about the workforce. There is, as I mentioned earlier, this great concern about the possible consequences of discovering you've actually adopted a whole raft of contracts of employment and given the employees super priority over the assets of the company. And in a nutshell, the administrators have 14 days to decide what they're going to do, although there's quite massive case law about what adopting a contract actually means. But the most typical thing that an administrator does is to try and identify a package of the company's assets and contracts and part of the personnel that can form a viable unit which can be sold on as a going concern. And typically then the administrator will form a new subsidiary, transfer or hive down, as we say, everything you need for that new viable business into the new company, and that will be then sold off normally to the highest bidder. There's nothing in the statute saying he's got to do that. It's just come to be what administrators do. But they could also, if they wish to, propose a CVA, a company voluntary arrangement. CVAs are very powerful tools. We see them all the time. You probably remember perhaps Debenhams getting into trouble every so often because they're stuck, like so many high street firms, with stores in the high streets up and down the country with whopping rents, and CVAs can be used to massage debts in all sorts of ways, to have a rescheduling of debts, to have an agreement to pay only a proportion of the debts, or to convert debt into equity and so on. A very powerful instrument, and crucially, coming back to Debenhams and the like, to alter the terms of a lease and reduce the rent, for example. Another possibility is a scheme of arrangement under the Companies Act. It's a bit more cumbersome. It's a subject all to itself, as indeed are CVAs, and I won't deal with them further here. But whatever the administrator has got to do, or whatever he wishes to do, what he must do under Schedule B1 is formulate written proposals and put them to the first meeting of creditors so that the creditors can approve them or not approve them as they see fit. Now that takes me to the next slide, which is the importance of the moratorium. The moratorium is the single most important thing about the, sorry, this is it's not an illness, it's pollen. the single most important thing about the administration mechanism, because it is a mechanism for protecting the company from its creditors. The administration lasts for a year, that can be extended, but it would be no good at all if at any time a creditor could simply present a winding up petition and torpedo everything. So no winding up petition can be presented or winding up order made, and if there's already a pending petition, it's dismissed. That is subject to a special exception for the Financial Conduct Authority. No step may be taken to enforce security over the company's assets. No step may be taken to repossess goods in the company's possession under a hire purchase agreement. A landlord can't exercise a right of forfeiture in England or irritancy of a lease in Scotland. And crucially, this is the sweeper up of very broad scope. No legal process may be instituted or continued against the company or any of its property. Now that, if there's existing litigation, that stops the litigation in its tracks. Now, these prohibitions, if you want to use that word, aren't absolute. These things can't be done except with the permission of the administrator or the court. So you can ask the administrator. If he says no, you go to court. And in fact, the case law establishes you don't even have to bother asking the administrator, you can go straight to court anyway. But this is powerful. I mentioned in passing a trap for the unwary. No steps may be taken to repossess goods in the company's possession under a hire purchase agreement. That looks crystal clear till you look up the definitions and discover that the definition of a hire purchase agreement includes a retention of title clause in a contract. So unless you look at the fine print at the end of Schedule B1, you won't discover that rather tricky fact. So that's the importance of the moratorium. And now I'm going to pass on to the next slide, which is really my winding up slide. Issues in administration. This isn't a comprehensive list, it's just my own experience of things that happen in administrations. And the first thing that happens is that again and again and again, it's discovered, sometimes after a couple of days, sometimes after months, that the company hasn't been put into administration properly at all. And the way forward for that used to be for what are called G-Tech petitions. That's under the name of the first petition to the court to put right an invalid appointment. And what the court is asked to do is, first of all, to reappoint exactly the same individual as the administrator, but crucially to backdate his appointment to the date of the erroneous appointment so that you capture everything he has done in the meantime and put it right retrospectively. That can now be dealt with under the Insolvency Scotland Company Voluntary Arrangements and Administration Rules 2018. In Rules 1.56 and 1.57 give the court power to sort this out. In fact, they're formalizing the power which the court already had. Another important point about administrations, and it's something which David mentioned, is pre-packs. Pre-pack administrations are very, very common indeed. And what happens is that when a company gets into difficulty, it consults insolvency practitioners. The practitioners might say, we think you need to package this part of the business together, sell it off, but we'll tee up everything now. Then when we're ready, we put the company into administration, and on day one, we do the deal, we hive down, we sell. That has become, it's attracted a lot of negative publicity. In fact, it's attracted criticism from the House of Commons. And because the feeling is that the company's goodies are being put in a brand new, clean company owned by the same people, managed by the same people, leaving the company's creditors to whistle for their money. And in England and Wales, there's now a statement of insolvency practice called SIP 16, Statement of Insolvency Practice, Pre-Packaged Sales and Administration. It doesn't technically apply in Scotland, but I think we should assume that the court would be very puzzled to find the company not adhering, the administrators not adhering to SIP 16, and it's making sure that the whole advertising and sale process is squeaky clean and transparent. The next issue that arises, it's too complex to go into. I just want to mention paragraph 99 of Schedule B1 looks on the faces of it. It was just telling us the order of payments in a company in liquidation and telling us that the ex-liquidator has what is unhelpfully for Scots lawyers called a charge, very English expression, over the assets of the company to secure certain things, it has become a minefield, and it has given rise to a lot of complex litigation. My penultimate point is perhaps predictably about the coronavirus job retention scheme. The statutory framework for this is the Coronavirus Act 2020. Section 64 of that act gives the Treasury power to give directions to HMRC. There is a direction in force. Among other things, HMRC are empowered under the direction to give guidance about the scheme. And I think my impression from talking to agents and clients is that most people have been looking at the revenue guidance on the Revenue's website as though the Treasury direction didn't exist. But in fact, the guidance has no statutory force in the sense of being binding law. We may in the future see people complaining that they followed the Revenue's guidance and discovered it's wrong. That might be the case, for example, in relation to employment law. So that's what we've got as a structure. There are two cases involving liquidators. They've only been heard in the last few weeks. One is Carluccio's, the famous Italian restaurant chain. The other is, of course, Debenhams, the high street store claim. What they were about, it doesn't really matter. The important thing is just to realize that there is nothing in the Treasury direction which creates the capital S scheme, the CJRS, letter by letter. There's nothing in that direction which excludes a company administration from accessing the scheme. The Revenue's guidance has a few things to say about when it would expect administrators to access or not to access the scheme. And these two cases were simply asking the court for directions in relation to that. And the mention of directions brings me to my real final point, and that is, remember, administrators are officers of the court. That's actually stated in black and white in Schedule B1, but it would be the case anyway. And the consequence of that, also stated in black and white in Schedule B1, is that the administrators can petition the court for directions. And I have had various occasions over the years when people have asked me, administrators asked my opinion about what to do in certain circumstances, and my advice, helpfully, has been to say, who cares what I think? The only way to have absolute certainty is to get directions from the court, because if you get those directions and stick to them, you cannot be wrong. And so that concludes this rapid canter through that area of the law. And with that, I am going to pass you on to Ewan Brown, who's going to talk to us about wrongful trading in lockdown.
Thank you, Michael. It may be remembered that fairly early on in one of the press briefings given by Downing Street at the end of March, an announcement was made by Alok Sharma that there would be a suspension of wrongful trading, or the wrongful trading provisions, for a period of 3 months. And so I'll consider those this morning. Before I do that, though, just to set the scene and to remind ourselves of the statutory background to this. The Insolvency Act in Chapter 4, Part 10, has a clutch of sections grouped together under the subheading penalisation of directors and officers. The most pertinent sections for current purposes today are sections 212, 213 and 214. 212, as you will recall, provides a summary remedy against any officer, including a director of a company, liquidator, receiver, someone who's been involved in the promotion or formation of the company, and indeed the management of the company, who is considered by the court to have misapplied or retained or become accountable for any money or property of the company, or they may be guilty of any misfeasance or breach of a fiduciary duty or other duty in relation to the company. And the result is that they may be ordered to repay or restore or account for money or property or any part of it which they have obtained. Section 213 is the section which deals with fraudulent trading, where the business has been carried on with a view to defrauding creditors or for a fraudulent purpose. And again, that provision applies widely. It may apply to any person who has carried on business for a fraudulent purpose or to defraud creditors. Section 214 is the section which provides for wrongful trading. Now, there's always a risk of trying to précis legislation, but the section was too long and too detailed to put it on a screen. But in essence, what it provides is that the court may declare that a director is to make a contribution to the company's assets if at some time before the commencement of the winding up, the director knew or ought to have concluded there was no reasonable prospect that the company would avoid going into insolvent liquidation or insolvent administration. And if the court is satisfied that there has been wrongful trading, the director may, of course, be ordered to make a contribution to the company's assets in such amount as the court thinks proper. There is a defence available, though, and that is where the director first knew or ought to have known that there was no prospect of avoiding insolvent liquidation or insolvent administration. They took every step with a view to minimising the potential loss to the creditors. So that is the background to it. If I can turn now to what the Business Secretary actually said during the press briefing on the 28th of March. He said there will be a temporary suspension of wrongful trading provisions for company directors to remove the threat of personal liability during the pandemic. The provision is to have retrospective effect from the 1st of March. However, to be clear, all of the other checks and balances that help to ensure directors fulfil their duties properly will remain in force. Now, during that press briefing, Alok Sharma also announced another couple of reforms to the insolvency regime, which Bill will cover, and I'll confine myself to the wrongful trading announcement. In a sense, it's maybe not surprising the government has been thinking about this. It has regularly said that its overriding objective is to help UK companies and to give them more time and space to weather the storm, all with a view to saving jobs and ultimately the economy. When announcing these measures, Alok Sharma said that the government had been asked to look at easing the burden of regulation for companies. I suspect that the Institute of Directors may have been involved in that particular aspect. And he also said that the aim was to give more flexibility while ensuring that directors do not incur personal liability for their decisions in these very challenging times. Just by way of an example of a measure taken by the government to ease the regulatory burden on companies, you may recall that an announcement was also made at this time that companies would be given an extra 3 months for lodging their accounts with Companies House. Turning to the legislation to give effect to the intention, the first point to note is that a draft of the legislation is not yet available. Now, it was said when the announcement was made that legislation would be brought forward at the earliest opportunity, but from a search which I've made of the House of Commons library as recently as this morning, I still cannot see anything further to by way of legislation, or draft legislation at least, on the topic. What is known, though, from the statement is that the legislation will be retrospective from the 1st of March. And in a Commons briefing paper, which was published shortly after the announcement, it was interesting that the briefing paper said that the measure would be for an initial period of 3 months. So perhaps the period will be extended once the full implications and the long-term implications of the coronavirus outbreak come to be understood. The other point is that the intention, at least at the moment, appears to be that the provision will apply to directors of all companies, not just those companies impacted by coronavirus. And I suspect that's because it may be very difficult in the end to identify companies which have not been impacted in some way by the outbreak and the expected impact upon the economy. The other point to note from the statement is that other checks and balances are to remain in place. Well, what are they? What could they potentially be? Well, obviously a director will not be permitted to create an unfair preference as a result of the suspension. They will not be able to make gratuitous alienations. The tension may come, though, when thinking about the general duties which directors owe. The duties which they owe to the company are to be found in the Companies Act 2006, Part 8, Chapter 10. And in particular, it will be remembered that under Section 172, while the director's primary duty is to promote the success of the company, under Section 1723, that of course is subject in certain circumstances to act in the interests of creditors. And from what I can see, there is no intention to change that, although perhaps as the legislation is developed, it will be realised that some modification of that subsection is required. And from what I've been able to gather, there is no intention to dispense with company directors' disqualification legislation or modify that in any way. So it's actually going to be still quite difficult for directors, I think, to work out whether they are acting appropriately, notwithstanding the suspension of wrongful diligence. With regard to the views of stakeholders on this, generally speaking, a question has been raised about whether the legislation is actually necessary. Do we need to suspend wrongful trading? The provisions are not commonly invoked. The courts appear to be slow to judge a director's conduct too harshly with the benefit of hindsight, except of course where there's very obvious wrongdoing. And where there is very obvious wrongdoing, then it's likely that the director will be caught by some other provisions, such as having created an unfair preference, having made a gratuitous alienation, or they will be subject to director's disqualification. So it's not, there's still some doubt about the benefit of it. However, that said, the Institute of Directors has said that the provision obviously gives greater room for manoeuvre when directors come to make their decisions. The CBI has been supportive. They've said it will give much needed headroom. The British Chamber of Commerce has said that it's a sensible provision and directors should not be penalised for doing what they can in these very difficult economic circumstances. R3, which is obviously the trade body for insolvency practitioners, has not been quite so enthusiastic, and indeed it has questioned whether it should be, whether wrongful trading should be suspended. It thinks that a blanket suspension runs the risk of abuse. Does it really assist those directors who are acting in good faith? Would they not have been protected anyway by the defences which are available? And does it run the risk of indulging those who are prone to acting in bad faith so far as the interests of creditors are concerned? The Institute of Chartered Accountants in England and Wales has said it's obviously a pragmatic step, it's a welcome addition to the desire to protect jobs, but their advice is that directors who find themselves trying to manage companies which are in difficulty should still seek advice on what they should do. From research which I've carried out, I'm not aware of the Institute of Chartered Accountants of Scotland issuing any similar guidance to its members, but I think the fact that the Institute of Chartered Accountants is recommending that directors take advice flags up an immediate problem for people like us who may be faced with having to give advice to directors. Inevitably, the devil will always be in the detail of a provision like this. We will have to keep an eye on it to see what actually comes through the legislature. It's unfortunate that we don't have anything yet. It's perfectly understandable, given all the other issues which have to be tackled, and this is just a very small issue, but it's unfortunate for us because it's difficult to advise in a vacuum. The paradox, I suppose, is that while it was intended to assist directors make decisions, it's actually difficult for us to advise them what decisions are appropriate until we see the legislation. Time will no doubt tell what the final shape of the provisions will be, and obviously as insolvency practitioners we will have to keep a very close eye on how those provisions shape up. Now with that, I'll hand over to Bill, who will continue the discussion about the measures which were announced by Mr. Sharma.
Well, good morning, ladies and gentlemen. Virtually so. I am going to follow on from Ewan, for which thank you very much, just to look at some of the other pointers that were raised by the Business Secretary and that are under discussion at the moment and indeed are before Parliament or will be very shortly. I've called my title A New Dawn or Just a Delayed Dusk, and I don't wish it to be a negative. But of course, the devil will be in the detail, and that is still slightly uncertain. So perhaps if I could ask for the first slide. I just thought I would start by having a look at some statistics. Now, obviously, these, as you will see, are statistics from England and Wales, but they are very up to date, and they show the number of insolvencies in England and Wales in the 12-month period ending on the 31st of March of this year. Now, you'll see immediately the sectors that stand out: construction, and then accommodation and food service, and indeed other notables, real estate, and indeed IT, surprisingly. Now, whilst these figures don't relate to Scotland, it's very clear that if a similar Scottish table was produced, that sectors such as construction and accommodation and food service would be pretty high up there, along no doubt with tourism, tourism-related businesses. So things are not looking all that rosy at all in these sectors. But that gives you an idea as to where things are on the ground. And someone's just pointed out to say, why can't we see Bill? So I thought I had, there we are. I hope you can see me now. Thank you to Joel there. Can you see me? So before we go onto the next, excellent. Yes, somebody can. Thank you very much, Andrew Scott. Perhaps we could go on to the next slide. Thank you. Wow, excellent. I've had a text as well. So what do we need? Well, business really is saying, well, give us the tools. Now, Ewan has spoken to you a bit about the winding up scenario and wrongful trading. But if I could ask to go on to the next slide, please. What I would just like to go over in, I'm afraid, very brief detail this morning, but to give you an idea, are really what's required, and that is restructuring tools. businesses need to know how much time they have and what they can do within that. Now, there's no doubt about it. At the moment, things are happening very, very quickly, and healthy businesses have effectively suddenly had the taps turned off. It's not a recession or a fall-off in demand for many businesses. It's a complete shutdown, and a shutdown that happened extremely quickly and unexpectedly. So to give you some ideas, the government at the moment are proposing new changes. Now, these new changes have been on the table since about 2016. So fortunately, there were detailed discussions ongoing in any event before the CV-19 crisis. And there was a lengthy consultation period in relation to changes to corporate insolvency. And a report on that, as you'll see at the bottom of this slide, was published by the government in late 2018 on reforms to corporate insolvency rules. Now, that report is very, very readily accessible on the internet. I'm sure many of you will have read it or be familiar with it. But fortunately, or indeed perhaps even serendipitously, the government were already thinking along the lines of making it easier for businesses who get into difficulties. So what is being proposed at the moment, and what, although there is nothing in the House of Commons library at the moment, it's certainly very high up the list of issues for Parliament. But what is being proposed is that there will be, in effect, a moratorium which will give companies breathing space from creditors so that they can sit and think without being panicked into acting to see if they can save the business, whether there is a restructuring proposition that would work, whether there is a rescue plan that could be entered into. And if a plan can be set up, can be created, and can be it is viable, then creditors, both unsecured and secured, will be bound to that plan. And one of the other important elements, of course, is that it's not just keeping the business going in the long term, it's keeping the business going in the short term. And that if a business suddenly finds itself cut off from its internet or its power, it's very, very difficult for it to trade. So what is anticipated is that there will be rules and regulations set out in statute that will protect supplies, urgent supplies or essential supplies, such as power and internet, to prevent suppliers terminating these supplies as a result of late or non-payment. So if we could go please on to the next slide. Some details in inverted commas, given that there is nothing that's absolutely certain. The first question, of course, you'll all be asking yourselves at the moment, and no doubt will want to raise, well, when is this going to happen? The exact date is unclear. And indeed, even this morning, I went myself to see if there was any update. There isn't. The exact date is unclear, but one would hope that it will be imminent, particularly because of the wrongful trading dates, which can be dated back to March of this year. So that what is proposed is that a moratorium will be available to all companies. There will doubtless be some exceptions, and that the test will be a prospective insolvency test. And that is, would the company become solvent if action is not taken, and that it won't be available to companies who are already insolvent. Companies would need to establish the prospect of rescue is more likely than not. And the key, of course, is that once the moratorium and the plan is agreed, it will prevent enforcement action from creditors. The moratorium, it is proposed, will last for about 28 days, with a possibility of extension for a further 28 days. And indeed, as in all cases such as this, there will doubtless be exceptions which would enable parties to make an application for a further extension if good cause is shown. Now, of course, creditors may well think, well, this is all very well for businesses, but what about us? Because we too have our own financial issues to deal with. Creditors' interests will be protected through the appointment of an authorised monitor who will monitor compliance with specified moratorium conditions. So this will, it is certainly it would appear will be a carefully regulated and followed up process by independent monitors who will ensure that whatever is agreed to, parties stick to. And indeed, the date, the length of these moratoriums is reasonably short, unless exceptional cause will be shown. The moratorium, it is proposed, will be triggered by simply filing the necessary paperwork in court. It's likely to be similar to the current procedure for the appointment of an administrator out of court, and a court hearing will be unnecessary. So these are very, very positive steps. It's probably the case that they would have happened anyway, given the government's consultation over the last 2 years, and it is hoped that it will happen before too long. I think in practical terms that professional advisors and indeed parties themselves will hopefully be able to enter into dialogue with potential creditors on the basis of what's coming and try and persuade parties, each other counterparties, to take a pragmatic approach in the absence of formal legislation or similar being passed. Now, what I would like to finish with in the brief few minutes that I have is perhaps to just look up, if we could look at the next slide, of looking up at the question of winding up petitions. Now, Michael has touched upon this. There is some real-time activity, if you like, in relation to this area. In general terms, it's very clear in both England and Wales and in Scotland that for the time being, the courts are not entertaining any material and formal hearings in relation to winding up. The courts in England have effectively closed to material hearings until at least June, and that was the case going back till middle of March. So parties have been, if you like, been given an informal additional period to try and sort out arrangements with creditors. What is important, as you will all know from your own practices, is that whilst the hearings have been delayed or assisted stayed, that doesn't prevent the paperwork from being filed or winding up petitions being, the process being started. And indeed, only last week, a landlord has sought to wind up Pizza Express as a result of non-payment of rent for one of the London restaurants, one of the London Pizza Express restaurants. Now, no doubt that step will perhaps focus Pizza Express minds as to perhaps paying the rent in that particular unit. But it does show you that not all landlords are either willing to play ball or indeed themselves are capable of playing ball if they themselves are facing mortgage repayments or other repayments. So there are a number of parties in every chain, and that certainly there'll no doubt be a bit of arm twisting on the ground, so that solicitors are no doubt still busy with filing the necessary paperwork, albeit there are going to be no hearings for the foreseeable future. Certainly from my own experience in Edinburgh Sheriff Court, it would appear that insolvency-related material hearings are all off until the 19th of June, when they were going to be revisited. Obviously, that's only 6-7 weeks away, but it shows that there is no desire to pursue diligence-related matters. And of course, in Scotland, the Scottish legislation from the Scottish Parliament is very strict about this, that there is, in effect, a moratorium on pursuing debtors to the nth degree at the moment. All of these things have to be welcomed. Of course, we don't know what's going to happen going forward at the end of the furlough period. We don't know for how much longer the government will be able to bail out what is now 23% of the workforce, and what impact the easing off, as is imminent at the end of June onwards, the easing off of the furloughing payments will have on business in general, and in particular on sectors that in Scotland, real estate sectors, for example, housing sales, etc., on the effect upon these sectors that we will see at the end of the summer, following what would ordinarily have been their most profitable period. So by way of finishing, ladies and gentlemen, I would simply say that there's a clear agenda on the part of the government, both in England and in Scotland, to make things as easy as possible for people, but business will have to start soon. Of that, there is no doubt. The doors will have to open soon. Really, at the moment, the key is communication and foreseeing and forestalling problems, and entering into discussions as early as possible with counterparties who could potentially cause trouble in the future. So thank you very much for tuning in today, and that is 12 o'clock. So on the dot, I will finish, and I think now I'll hand back to our chairman, Michael Hyland. Thank you all very much.
Thanks, Bill, very much, and indeed thanks to you, and thanks again to David. There may be, I know we're overrunning very slightly, but there may be an incoming question, because there's a fifth chat, and I think Emma's trying to ascertain whether there is a question seeking to ask itself, but nothing seems to have come through. I think we've got a screen with some contact details which people might want to look at. I may be wrong about that. I may be wrong.
Screen.
Yeah. So, well, thank you everyone once again. I hope people found that helpful. The point I think to take from all this is that everything we've heard is absolutely the tip of the iceberg. This is a massive subject. It does cross my mind that my own speaking notes that I look at while giving this talk are to some extent a bit more detailed than what I ended up saying, and that might be the case for David and Ewan and Bill as well. So there may be some people who want to ask for fuller notes, in which case I'm sure we can supply them. Meanwhile, there is one question on the question and answer. So if Em can help us, do I click on that perhaps to see what's happening?
It was more a comment. One of the panelists said that it was an excellent presentation, but made a comment that, of course, many companies may simply ignore the problem and will not take advantage of the new provisions.
Yes, yes, yes. I'm astonished, actually, in the work that I've been doing over the last few weeks, how many companies have got stuck straight into this, actually. Particularly looking at the job retention scheme and saying what is in this for us. And the revenues guidance actually does make it clear that one of the purposes of the revenue recognition.
Somebody's put up a very interesting question. What duties do administrators and liquidators have to avoid conflicts of interest?
That's a very good point. And of course, anybody in charge of the affairs of the company has a duty to avoid conflict of interest. And the classic situation actually is where you have a company which has been in administration, and then you get to a stage where the administrators say, well, that's it, we've done all we can, there's nothing left now except to put the company into creditors' voluntary liquidation, which they can now do, as I said, just by filing a form at Companies House. But then you have the strange position where if someone needs to look back at the conduct of the administration, possibly with a view to criticizing it, possibly with a view to taking action against the administrators, that's not going to get you very far if the person who's best qualified to do it, the administrator, the liquidator, happens to be the ex-administrator. And so the fact of converting oneself from administrator into liquidator is not necessarily going to lead to conflicts of interest, but emerging conflict, there is serious criticism of the conduct of the administration, because it would normally be an independent liquidator who would be best placed to examine that and challenge that and raise proceedings about that. I don't know if that's any help.
I would also add to that, Michael, the point you made in your main talk, which was in relation to pre-packs. I think that's one of the major problems in pre-packs, is that administrators get very close to the directors of the existing company. They facilitate a deal whereby a lot of the creditors essentially are dumped. The principal assets on which they granted their security or granted their credit are taken away from them. And then everybody lives off happily ever after, except the poor creditors who are left with very little to claim. And in those situations, I think a lot of administrators sail quite close to the wind, frankly, and it's going to be a subject for in professional regulation in due course, I suspect.
Well, that's why, interestingly, SIP 16 that I mentioned, the Statement of Insolvency Practice, is helpful, because if you look at it with a slightly cynical eye, you might think this is not so much an SIP which tells administrators how to get it right, but more of an SIP which tells administrators how to avoid getting sued. But it is certainly worth a good read. There's another question, question 2, or perhaps we've already had that, I don't know. Emma, what do you make of question 2?
Question 2 is, what is the panel's views of the pros and cons of the so-called light touch administrations where directors are empowered to continue to manage the business with the consent of administrators in the recent Debenhams appointment?
Can I say something immediately? There's an international aspect to this, because we always hear in the States of companies going into Chapter 11 bankruptcy. And one of the big points about Chapter 11 bankruptcy in the States is that the board of directors stay in control of the company. So having got the company into difficulties, they then have the benefit of a statutory moratorium, which under a Chapter 11 sometimes it goes on for year after year after year, in which to put right the things they've already got wrong earlier. I mean, but there was one airline in the States which traded under Chapter 11 for a prodigious period of time, benefiting from the protection from its pre-Chapter 11 creditors, giving it a huge competitive advantage over other companies. Now, light touch administration, my experience is that although it sounds nice, there's not a lot of it about. And that's because the touchstone for going into administration is that the company either already is insolvent or it is about to become insolvent. And one of the problems for the directors at that stage, one of the things that make an administration attractive is the directors can say, well, if the administrator is in control, we are no longer to blame for anything that happens from the point of administration onwards. And that's why I think that we will, although they're an interesting phenomenon, I think they're more like a tiny blip on the screen rather than anything of significance.
There is one further question. I wonder if we would answer this and then finish up the seminar. So the final question is, can liquidators bring wrongful trading claims if appointed post-March, but before the wrongful trading rules came in? And would those actions be allowed to continue if the rules change?
Now, is this something for Ewan or for Bill?
Yes, I think it probably is. I think it's actually, I'm not trying to avoid the answering that question, but I think at the moment there is simply no answer to that, because what you would expect normally in a situation like this is there will be some form of transitional provision contained within the regulations, or however the government chooses to bring in the provisions. So I think that's something we will obviously have to think about as the legislation is published. I'm sorry I can't answer it at the moment, but I think that's the honest answer to it.
May I say, I'd just add briefly to that, I think that the reality is, as Ewan pointed out in his principal talk, and Bill as well to a certain extent, is that there are many strands on which malfeasance directors can be caught, and this is only one of them. And the likelihood is, if they're guilty of wrongful trading, even if that might be protected, they're also going to be guilty of other things. And Section 212 in particular is a very effective weapon against directors who've misbehaved themselves. So the sensible thing to do would be to bring the action under a different section at the moment.
I'd just like to thank everyone for their questions. If there is any follow-ups, then people can email me. I will also be emailing out the slides and a link to the recording when that's available.
Thank you. Well, I think we just say goodbye to everyone now, and thank you very much for logging in. I hope once again you found it interesting. Thank you, Emma. Thank you, David, Ewan, and William. Bill.
Thank you, Michael. Thank you, Emma. Thank you, everybody.